Good morning, Andrew.
How are you doing, Gavin?
Good and you, my man.
I'm glad to share some time with you.
Excellent. Yeah, we haven't done this in a while. And,
Yes.
for everyone out there, I'm sure you all know Andrew, a very seasoned campaigner and one of the few people that I look up to as a mentor and somebody who is a stalwart in this industry. So it's my absolute privilege to have this discussion with you on round two. Last one we did was on the undertakings judgment. I did with Mornay, who also cut his teeth under you. And this one is quite an important one on the foreigner judgment, the Mudawo judgment.
Very firstly, thank you for those kind words. I hold you in that high regard as well. And yes, I think this is a pivotal judgment in the whole RAF landscape right now. And a lot of people are wanting to know a little bit more about it, and I think excited about it because our judiciary, in my view, has pulled through here.
Absolutely. I think everybody's sort of holding out the big three.
Yeah.
This one and strike one to the RAF already. We've got the pending discovery health judgment, and then the very big one for all plaintiff attorneys, the lodgement directive,
Yes.
the LPIIF case. One that's very close to our hearts with our history. So I think, just by way of kicking it off, everybody knows what this was about. The fund unilaterally introduced this errant thing, and I always remember the day. It was the day before my birthday in 2022. And literally just said, as of today, we're cutting it off. If you can't qualify that your client is here legally on a work permit or is a South African citizen, they will not be paying any damages. And my first act at that stage was to approach the fund and say, just help me understand this. And I never got a response, by the way.
Yeah.
You say you're not going to pay out the foreigner. Let's just put this into practical terms. You're the foreigner, I'm the South African citizen. I ride into you, I cause your damages, I cause you injury. Now they're saying they're not going to pay you out, but I'm the insured driver. So the fund covers me and pays you out. Now they're saying they're not going to pay you out, so they're reneging on my cover that I'm paying for. So I should go and ask my premium back if I've caused you injury. So it's totally iniquitous. If they don't reverse the common law right situation and reintroduce the common law right to sue the wrongdoer, how are you as the foreigner supposed to recover your damages? Because we know, the Act's very clear. The Immigration Act and everything around it is a legal foreigner, well, we'll get to the legality and the illegality,
yes.
has all the rights and privileges of a South African citizen, save for a couple of things like the voting and certain jobs like in the police force, security forces and that.
Absolutely correct. And what I did when that June 22 day came, the very first thing I did is I went for a refresher. I looked at the legislation. I went to the core. I went to the RAF Act. And I said, but what exactly does Section 17 say? And if you read the words, they're very clear, unambiguous. And that's what's come out now in this Mudawo judgment. The words are unambiguous. It's clear. It says any person in Section 17. And that's what our judges have taken into account. I think the position was at that time in June 2022 when the RAF chose to introduce its own internal policies or whatever, very short-sighted. They didn't know the impact of what they were doing, and it was almost working outside of the law.
Exactly right, and I think if you look at the overlap, it's going to be very interesting with the LPIF judgment because specific reference is made to the new claim form, unlawful claim form, let's just add, specifically paragraph 6.1 and 12.1,
Yes.
I think it is, where the requirements for a legitimate claim, if you're a foreigner, in terms of a loss of support claim or an injury claim. So that's been, we know the impugned provisions, they've been challenged, and the minister served a notice to abide. So the court has now spoken on that. So that's definitely making inroads into that judgment that's coming out, and it's made it even more positive in the favor of the plaintiffs.
So there's going to be some impact on that judgment as well. This judgment must have some impact, I understand. And you're right, Gavin. But there's consequences as well for the RAF. There's a bigger picture here as well.
Right.
Did they see this coming? I don't know what you think. I think they should have, because the courts have already pronounced on these foreigner claims already. A lot of attorneys chose, well, let's hold on, let's see what our appeal court says, and they've approached it that way. But if I was the legal representative of the Road Accident Fund, I would have prepared them for this judgment.
Well, correct, and let me just switch over to the discovery matter. Discovery
Yes.
actually said, pending the outcome of this case, we will, if you revert back to the old payment system, we will ring fence any money that gets paid out in case we lose down the road. Now, I hope the fund has done that, because they should have realized when they lost in the court AQO and it went on appeal and they subsequently lost on appeal, they should have ring fenced those, especially for the matters that have become settled out of court orders, because they're going to be due and payable now. I mean, the
Yes.
relief they sought, was the suspension of the writs so that the assets couldn't be attached. So I see a deluge. I would hate to be in the hot
That's
seat of the
now out
fund
the
now
window.
making the call.
Yes.
Yeah, it's crazy. If you revert back to this judgment, I found it quite laughable that if you have a look at, it's the 1996 Act, and the now erstwhile CEO of the Road Accident
Yes.
Fund actually said in his founding affidavit that this is something that the court shouldn't get involved in. This is an executive decision. And that secondly, he goes on to try and interpret what he feels the legislator intended under any person. That any person only refers to South Africans, legal foreigners. It doesn't refer to illegal foreigners. I find it quite ironic, because around 96, we're talking, 30 years ago? I don't
Yes.
even think the CEO had a driver's license at that stage, given his age. So it's quite ironic that he would want to pronounce on that. But I think everything has come together. I think it's a very sound judgment. Let's quickly talk about the roll-on effect, Joe, because how do they, and the judgment's silent on this, and I'm a little bit perturbed about this. I don't know how it's going to be dealt with. People that have been turned away, foreigners that have been turned away, or their cases objected to or repudiated based on foreigners, based on this illegal directive, how are they going to go about giving them a second bite of the cherry now? This could be quite catastrophic for the fund.
Absolutely. I think, just going back on that one point, the internal, what the court clearly says, the internal policies of the RAF can't be above the law.
Exactly.
And that was always a problem. The suspended CEO, or whatever you want to call him, Mr. Letswala, believed that he was. And that's an unfortunate thing. I think what's going to happen now, the knock-on effect, is that all the attorneys representing the foreigners are going to mobilize. They're now going to breathe life back into all those claims. They're going to make contact with and they're going to give momentum to those matters now.
Exactly.
And it's going to have an impact on the RAF.
Right.
The cash flow, the ability to meet their obligations in terms of the law, in terms of the judgments that they've already secured, in terms of the writs that are there. And your point is a valid one, Gavin. What have they done? What has the RAF done to prepare itself for this?
Correct. Look, let's look at it holistically. If they want to, and let's look at it from a different perspective. If you or I travel to the States or any place abroad, we have to have insurance before you even get a visa. Now, this is the only country where you don't require that. So I can see where they were coming from, what their point of reference was. It's a case of, if you come to our country, make sure you have the coverage. But if they want to do that, change the act. You can't bring out a provision and say it overrides the act, which is what the fund purported to do here.
Literally,
So,
yes.
They went about it incorrectly, and they need to take it on the chin, and they need to understand that going forward, if they introduce this, I actually feel that it would be a very valid point. They would still have to get around, think about this, even if they change the any person, if foreigners are excluded.
Yeah.
Will a foreigner receive a discount card when he puts fuel in his car when he works here, because he's not contributing to the fund? So why should he be paying if he's not going to be covered?
Yeah.
So that'd be quite interesting.
Very interesting. And I think in the background, and I don't know how the legal representatives and the legal team of the RAF are going to approach this. I think in the background they must be doing some thinking about this. I really do. And I think maybe that they may, if I was their legal representative, okay, let's accept this. But in the background, I believe there's things happening.
Right.
And I think it's going the route that you say. they recognize that the system's not working now, and the only way that that can go or should go is to change the legislation.
Sure. One point I want to touch on as well, Andrew. I've had a number of attorneys calling me, specific provisions. So the fund relied heavily on the Immigration Act, saying that they can't aid or abet an illegal foreigner. It goes against the Immigration Act.
Yes.
This judgment completely blows that out of the water by saying that any person trumps everything, right?
Yes.
So it's regardless of whether you're here illegally, whether you're here legitimately, whether you came via the Limpopo River, or
whether you
however
got a
you got
permit or
here,
not,
makes
yes.
no difference. You are entitled to coverage. A lot of attorneys are saying, yes, but what about the provision that specific jobs are reserved for South African citizens only? For example, the police services, or artisans, certain artisans or professionals.
Yeah.
So I think, and this is where the court's saying, you can't take it to the nth degree. And the fund are trying to say, if you are an artisan and you've been employed by employer X, they're saying they can't aid and abet and pay you for those damages because you're in an illegal job.
Yes.
But it's so far removed, right? So what they're saying is if you're employed as an artisan, there's the offense that's being caused. The government must take it up with that employer. It's got nothing to do with the damages you've suffered. So I think this judgment encompasses that. So I think the takeaway for attorneys is don't be perturbed if you have a foreigner that falls under that Immigration Act clause that's only specifically, relates to South African citizens. It's irrelevant. Any person is a very broad description. It covers anyone and everyone, provided you are involved in a car accident,
Yes,
and the fund's liability exists.
Yeah, and you meet with whatever they need, other aspects to comply and to be able to enforce your claim. And I think that the judgment goes further, and I think rightfully so, and raises what is entrenched in our Constitution, and say there's certain constitutional rights. Exactly right. And they raise that.
Yes. And
they say this is so. RAF Act is social it's a social insurance, if we can put it that way, for want of a better word. And they say, well, certain rights are entrenched, and there they are in our Constitution.
You're right.
So that's what they really, what the judges really looked at as well, and
correct,
and gave meaningful effect to.
Yeah, absolutely. I think it's a resounding victory.
Yes.
And as with anything, the only time the Road Accident Fund has acted correctly in the implementation of something new and quite prolific was with the 2008 amendments. They're not applying the retrospectivity aspect at all, right? They're saying as of today, the same as in the Lodgement Directive, as of today, it should be based on the cause of action, right? So in 2008, they said any accident that occurred on or before the 31st of July 2008 fell under the old provisions.
Yes.
Everything post 1 August onwards would fall under the new provisions, date of cause of action.
Yes.
Now, if the fund doesn't apply that principle, they're always going to face this dilemma, because it's going to open the door to prescriptions. Because if you suddenly have a matter, as of today, I have to lodge it in a certain way, but it's so close to prescription, you're dead in the water. And the client is prejudiced, and all the constitutional issues come up again. So I look forward to having this discussion with you when the other two judgments come out.
I'm glad for the victory of that victim out there, and
absolutely,
the rights are being looked for, and always a pleasure talking to you, Gavin.
Excellent, Andrew. Thank you. Have a power day.
And you too.